Good morning, everyone. Thank you for joining us for the third and final session of estate planning. This is how to avoid the probate process. My name is Kim Murphy. I'm the marketing specialist here at Birch Hill. And we'll get started with just a few housekeeping items. Everyone is on mute, but you can submit questions at the in the Q&A box at the bottom of your screen. We love suggestions on how to improve or ideas for future topics. So if you have something in mind that you'd love to learn more about, just let us know. This presentation is being recorded, and in a few days you'll receive an email with a link to the recording to view again or share with your friends and family or colleagues. So Birch Hill is a Riverwoods Group community, and the Riverwoods Group is the largest independent family of not-for-profit CCRCs in Northern New England. It was founded in 1994 in Exeter and grew to 3 community or campuses in Exeter. Birch Hill joined the Riverwoods Group in 2016 as the only Type B CCRC. Riverwoods Durham opened in 2019. And SPE is the very corporate term for someplace else. So we recognize that there is a need for continuing care retirement communities. And when the time is right, we'd love to cautiously grow. So what is a CCRC? And my apologies if you've attended all 3. This is the 3rd session that you're attending and you're getting this again, but now you really know. A CCRC is an insurance product. In addition to being a lovely retirement community. So our contracts are regulated by the state, and our financial performance is reported to the state of New Hampshire every year. So because we are an insurance product, it's considered prepaying and insuring for your future assisted living or nursing care needs. And because it's an insurance product, a portion of the entrance fee and the monthly service fee are also tax deductible, which is a big benefit. But more, also very important to that is that it's a lifestyle choice. It's a choice of optimism. So people enter while they're still living independently, and they want to free themselves from the burden of home maintenance and chores. There's services and amenities at every level that include transportation, dining options. There's a full calendar of activities and programs, fitness classes, education opportunities, lectures. So it all leads to increased social options and less isolation, if that's become something that you're concerned about. But it also allows you to stay in control of your life. And what I mean by that is that a continuing care retirement community answers the question of what your healthcare is going to cost, the quality of the healthcare that you're going to receive, the availability, and the location of the healthcare. So you're making all of these choices. You're staying in control, and you're not burdening your family or loved ones with making these decisions for you in a crisis. So you would enter at the minimum age of 62 when you're still living independently. There's 3 levels of care, at least in most CCRCs: independent living, assisted living, nursery care, and memory support. And residents have the option to transition between the 3 levels of care as their needs dictate. So in independent living, our residents receive 33 days of respite care every year. So they can, if you have a healthcare event, you can transition to assisted living, get back on your feet, and move back into your independent living apartment. As I mentioned, there are services and amenities, and that, it's only continuing to get better. There are 2 fees, as I mentioned, the entrance fee and the monthly service fee. And that also includes a benevolence clause. And this is something that is common to not-for-profit CCRCs. And this means if you outlive your assets through no fault of your own, you can apply for benevolence, and the community will cover the cost of your service fees and healthcare costs. So Birch Hill's been in Manchester for over 100 years, close to 150. Started as the Ladies' Aid Society, changed to Pearl Manor, Hillcrest Terrace, Birch Hill Terrace, and now Birch Hill. It became a CCRC in 2009 and joined the Riverwoods Group as a Type B contract in 2016. Affiliating with the Riverwoods Group meant that there were some beautiful renovations and expansions done to our community, including a brand new multi-purpose room, fitness center, and a lot of the apartments have been completely renovated. So because we've taken a number of apartments offline to completely renovate them, it's resulted in immediate availability. So you're not going to find a long wait list like you would at other CCRCs. Although we are located in Manchester, you probably wouldn't know it if you drove here. We're in a beautiful country setting, but it's just 10 minutes from downtown, 20 minutes from Concord. And we're located across the street from the 600-acre Nature Conservancy on Countryside Boulevard. So it's definitely not what you'd expect for Manchester. We're located in a beautiful northwest corner near Hooksett. I'm just going to talk for a minute about our innovative 70% contract. We're the first community in New England to offer this flexible contract. And what makes it so innovative is that you can use your 70% refundable entrance fee during your lifetime to offset healthcare costs, or you can save it for asset preservation for your estate. You have the flexibility to make that choice. So because you can use your money in a flexible way, it's more affordable. This contract has lower entrance fees and lower monthly service fees, so it's a better value for couples. The second person in a couple isn't going to pay the same and full entrance fee. There's a smaller second person entrance fee. And because you have the flexibility to use your cash flow, your out of pocket never changes. The other really great thing about a Type B contract is that you can use your existing long-term care policy along with our healthcare to offset the cost as your needs change in assisted living, nursing care, or memory support as well. So it really is, it makes your out of pocket a lot more predictable, and it's a flexible, better value. So just, it seems to be like there's a sort of generational villainization of retirement communities with COVID. And it really couldn't be farther than the truth. Sure, we are in long-term care, but as a CCRC, we're better equipped. There's professional nursing staff on site, housekeeping staff. There's been constant access to PPE, sanitization, testing, and now vaccination clinics, which is very exciting. The Riverwoods Group in general has been very aggressive about safety, taking steps at every turn to keep our residents as safe as possible. But that being said, there's still greater access to community. Residents are able to participate in small group classes, fitness opportunities. There's still access to, go outside and go for a walk and connect with people. So you're not isolated, even during a pandemic, which we've heard is a growing concern. As a CCRC, we continue to provide meals every day, grocery and prescription and mail delivery. And there is on-site healthcare right in our wellness clinic. And our nurse practitioner will actually do in-home visits from time to time as well. So without further ado, I'm going to introduce Jennifer Rivett, who is a shareholder at Devine, Millimet and Branch. And she's going to share what she knows about how to avoid the probate process.
Good morning, everybody. Thanks again for taking some time this morning to sit here with me and learn a little bit more about estate planning in general. And what we're going to talk about today is the probate process, and more specifically, how to avoid that process to the extent that it makes sense for your planning. If you were with us last week, we talked a bit about just estate planning in general, and one of the primary benefits to estate planning, and in particular using trusts, is to avoid the probate process. And we say that a lot as planners, but I think a valid question is, what is probate, right? Why do we want to avoid it? What is this process? So today we'll be talking a bit more about the probate process in general, and again, how to avoid it. Probate is a court supervised process by which we distribute the property owned by a person who has passed away. And that process can be governed either by a will, or in certain circumstances, somebody's passed away without a will. Their assets still get somewhere, and we have a statute that will tell us where those assets will pass. But nonetheless, the court oversees that process. Each state has a probate process. Each state's a little bit different, but each state does have its own process. Here in New Hampshire, it is a division within what we call the circuit court, and each county in New Hampshire has its own circuit court. So within that court is a probate division that oversees the probate process. And probate in our discussion today is really discussing how assets pass, once somebody has passed away. But probate can also cover other situations, particularly here in New Hampshire, like guardianships of incapacitated adults, guardianships of minors, some trust questions that might come up. But in general, today we're just going to be talking about the probate process as it relates to assets passing upon the death of someone. In New Hampshire, the county where the decedent, the person who's passed away, resides is the county within which we are going to probate their estate. That is also true if you live in another state, but you own real estate in your sole name here in New Hampshire or in another state even. The probate is going to occur in that county where the real estate is located. But in general, depending upon where you are, where you're living when you pass away, that's the county that we're going to be in. So probate, because it is a court overseen process, is open to public inspection. And what I mean by that is that your probate estate is part of the court record, and interested parties, and some probably non-interested parties, can come and review certain aspects of your probate record. So in general, the probate is governed, as I mentioned, by a will. And a will, as we discussed last week, is really a document that tells us who is going to settle your estate, who's the executor that you choose, who is receiving your assets upon your death. And the will itself is a formal document. And each of the states, again, is going to have their own requirements as to how a will is determined to be valid, right? So again, here in New Hampshire, there are certain requirements for a will to be valid. So for example, that will must be signed. It must be in writing, which seems kind of obvious, but it does. But certainly signed by the testator, the person who is establishing the will. And there are also a minimum number of witnesses to that will. And those witnesses are there when the testator signs. They must be present. And they are there to validate that the person signing the will is indeed the person named in the will. It's your will. They are also there to validate and verify that you are signing that will on your own free will. Nobody is making you do that. You're not under duress. And those witnesses can also attest or validate that you are of sound mind. You know your name. You know what assets you have. You know where you want those assets to pass. And all of that is really important because those witnesses may be called later on when a person passes away. We present the will to the probate court. And those witnesses can attest that on February 16th, 2021, I saw John Smith sign his will. I may also have signed an affidavit stating that, but John Smith is of sound mind. Nobody was making him do it, and it was indeed John Smith. So all of those requirements, again, vary from state to state, but typically will require a certain number of witnesses. In New Hampshire, we can also have what we call a self-proving affidavit, which is attached to the will, which essentially allows those witnesses to attest on that particular day. John Smith was who was signing the will. He was of sound mind. He was under no duress, and we're going to acknowledge that today. So in the event that, a witness can't be found when the will is presented many years from now, to the probate court when John Smith passes away. Those witnesses have already attested, and we can rely upon that statement or affidavit to present the will as valid. Again, the will is going to tell us how the assets are going to be distributed upon death, of course. So those assets can go to individuals, those assets could go to charitable organizations, or those assets may pass to a trust. So the probate process itself, again, is a process. And because we're in a court, we need to start that process. So after we learn that someone has passed away, we take the original will and we file that with the probate court, along with, in all likelihood, a petition signed by the executor who says, I'm named as the executor in John's will, and I would like the court to appoint me to have the authority to settle John Smith's assets and estate, and settle all of his affairs. Of course, whenever we start a probate petition, we also need an original death certificate. We need to know that the person is indeed dead before we can start that probate process. In the probate process, one of the more important aspects of probate is that all interested parties receive notice that the probate is commencing. So the petition is filed with the probate court, and part of that petition is asking who are all of the interested parties. So that can include everybody who might be named in the will to receive assets. That also includes heirs at law who are not named in the will. So you may have a will that, John had 4 children, but he's only named 3 of those children. That 4th child, still receives notice that the probate has occurred and is open, and they are an interested party whether or not they are named in that will. Creditors of the decedent also receive notice that the probate is being opened, and creditors have certain rights and filing requirements in order to ensure that their claim against the estate is known and that they ultimately get paid. So the notice is really important, and again, that's part of that process. And then assuming there is no objection filed, and in all of these interested parties, part of the reason that we want them to receive notice is that they will have an opportunity to object. So if somebody finds that, the will that we have submitted for John was dated 1978, and I know for a fact that he signed a new will in 2021, and I actually have that original will in my hand, I'm going to object to the petition that was filed and bring forth the will that I know is the most current will, and that's the will that will govern. There might also be an objection to the person filing the petition to be named as the executor. Perhaps we don't think that's the right person for that job. So there is a period of time where any of these objections can be raised, but assuming no objection is raised or any objection raised has been satisfied, an executor is appointed by the court. And that executor may have certain conditions upon their appointment. They may have to file a bond, but nonetheless, they are subject to the court's jurisdiction. And where this becomes important is that that executor may be called into the court to answer questions or address something that has come up throughout the probate process. And if the executor does not live in the state the probate is occurring. So I get this question a lot. Can I name a child as my executor, even though they live in North Carolina? And you can. If there is a probate administration that needs to occur, the executor need not be a New Hampshire resident to file a petition or serve as executor, but they may need to appoint or name someone who is a resident agent who will be located in New Hampshire or whatever state the probate is occurring to be able to receive service, for example, or perhaps appear on behalf of that executor. So your executor can be from a different state. They just need to be sure that they're following the process and have a designated resident agent within the state of the probate. So the probate process has a certain number of court-driven deadlines. So as I mentioned before, the creditors need to receive notice. So if somebody is owed by the decedent, they must receive notice of the probate, and then they have a period of time within which they can come forward and raise their claim and let the executor know, John owed me money for this, and they get on a list to be satisfied down the line. Other filings are also driven by deadlines. So for example, we may have to file an inventory of all of the assets in the decedent's sole name. That has to occur within a certain period of time and has to be pretty detailed. And then there is ongoing court oversight and approval of certain actions during the administration. So for example, there might be certain assets that we want to sell during the probate process, such as real estate. We need to get court approval in some states to be able to do that. We might want to make the distribution of some assets before the probate has formally closed, an interim distribution, in which case, with court approval, we can do that. Or if we have an asset that is in the decedent's sole name, that it's an ongoing business and it really would benefit the estate to have that business continue. The operations continue, it's generating income, or perhaps we're going to liquidate or sell that business, but in order to maintain the value, we want the business to continue during the probate process. We can get court approval, assuming that's the appropriate course of action. The court will approve that continuation of the business. So ultimately, when we get through all of these steps, we will eventually close out the probate. That can be done in a couple of different ways. And again, each state is a little bit different, but in general, often it can be closed by a motion. All of the interested parties validate that they are satisfied with everything the executor has done. All of those creditor claims have been paid. Income taxes have been filed. The executor's really done everything that they need to do. And everybody's in agreement, the executor can file a motion to close out the probate administration. And then the court will review that, make sure that, that is indeed the case, close out the probate administration. The court may require that the executor bring forth a full accounting of all of their activities done to date. There might have just been a more complex estate. There might be a requirement within the will that there be an accounting filed. One of the interested parties may request the executor to file an accounting with the court to review everything that occurred during that administration. So the court may require that before closing out the probate process. Once that probate has been closed, there's a final distribution of assets pursuant to the terms of the will. So oftentimes we will see a will that says, after the payment of all debts, expenses, costs of administration, the balance of my estate goes to my trust, or the balance of my estate goes to my children equally. So that final distribution can then occur once we know everything has been paid, settled, all aspects of the administration and estate administration have been satisfied. If an executor was required to post a surety bond as part of their condition to serve as executor, then that bond will be discharged. And a bond generally is really just intended to be almost an insurance policy to protect all of the interested parties of the estate, to ensure that the executor will show up at court if called, and that the executor does everything that they need to do. So that's in general, very briefly, the probate process. And again, depending on the state, it can take anywhere from a minimum of about 6 to 8 months to some probates might occur or go on for quite some time, for several years, depending on the complexity of the estate, depending on the complexity of the beneficiaries. So again, when we do a lot of planning around probate avoidance, there are some things that we can do. How do you avoid the whole probate process? You don't have any assets in your sole name when you die. Easy enough, right? So again, probate will only govern those assets that are in your sole name when you pass away. So that does not include assets that are owned jointly, for example, assets that have a designated beneficiary, assets that have a transfer on death or payable on death type of designation, and assets that are held in trust. None of those assets pass through that probate process because they're not in your sole name when you pass away. So jointly held assets, or a joint tenancy, is created by the way an asset is titled. So again, different states will treat this a little bit differently, but in general, a joint asset or a jointly held asset is going to have some special words around it, right? So it might be held as joint tenants with rights of survivorship. You may just see the word joint or JT, some indication that that asset is truly a joint asset. And the key to a joint asset is that each owner has equal rights to all of the property. So if you own a bank account jointly with another, each joint owner has complete access to that account, regardless of who has contributed to that account. And under a jointly held asset or a joint tenancy, The property or the asset that is held jointly will pass to the surviving owner when one owner passes away. So that just happens by operation of law. We don't need the probate process to get, or we don't need to pass that asset through the probate process. It just passes to that surviving joint tenant. An asset with a designated beneficiary also does not have to pass through the probate process. These are typically assets that we think about that are contractual. So for example, a life insurance policy or IRAs or other types of qualified retirement plans or annuities all may have designated beneficiaries. And if the beneficiary you name to receive that asset upon death is alive upon your death, that asset will pass to that named beneficiary through the designation. You may be able to name the trust as a beneficiary of some of these assets, and oftentimes we will do that if there is a trust as part of the estate plan for a variety of reasons. But you may recall, as I mentioned last week, there are certain changes to some of the laws that are governing IRAs in particular, and whether or not a trust really does make sense as a designated beneficiary. So that is something to review with your estate planning counsel. And under beneficiary designations, you may have primary and contingent designations as well. So if the first person, or generally person, but if that first beneficiary is not alive when you pass away, you'll have the contingents who can receive that asset. And again, it passes outside of the probate process so long as we have a living beneficiary who's been named. A transfer on death designation is very similar in that you can name a beneficiary or a person to receive an account when you pass away. That is different than a joint account. So unlike a joint account where the joint owners can have access to the account, a transfer on death designation means that the account will pass to the person named upon death, but that named person does not have access to the account during lifetime. A transfer on death designation also, again, passes to that named person outside of the probate process. It's not controlled by the will or trust. It just passes to that person outright. Brokerage accounts or bank accounts are often what we see with these transfer on death designations, and it's very institutional dependent. So some banks or brokerage firms will allow a transfer on death or payable on death designations. Some will not. So again, working with your financial advisor or your institution to see if this is an option is certainly worthwhile. But as long as your named beneficiary is alive when you pass away and there's someone to receive that account upon death, it passes outside of the probate process. And then finally, as we've talked about in a couple of sessions now, assets that are held in trust do not pass through the probate process. They are owned by the trust and they pass under the terms of those trusts. The key to making sure assets are held in trust is, again, how is that asset titled? So, for example, we have John Johnson, and he right now is the trustee of his trust because he is alive. And generally under these types of trusts, they're revocable trusts or living trusts, and you have set them up during your lifetime. You continue to be able to access those assets, control what goes in and out of the trust, control what occurs with the trust, amend the terms as need be. So during your lifetime, you're probably your trustee of your own trust, and then you name successors. But in order to be sure that that asset is in trust during your lifetime, so it will pass outside of the probate process, make sure the title to the asset indicates that it is in trust at the present time. If you place an asset in trust during your lifetime, odds are it is what we call a grantor trust. And what that means is if that's an asset that generates any income, that will be taxed to you as the grantor, as the person who set up the trust. And again, it makes for a pretty simple transfer during lifetime, but once it's in trust, will pass outside of the probate process at death. But just keeping in mind, just because an asset is in trust, any income earned is still going to be taxed to someone, and generally it is taxed to you as the person who has set up that trust. Just a brief review of what trusts are. Again, a document that has information about how your assets should be managed during your lifetime and at death. You name a trustee who's going to carry out the instructions you leave. And those assets can be titled in the trust during your lifetime. And again, that is key to avoiding that probate process altogether. A trust allows us to treat beneficiaries differently, and that might make sense if you have younger beneficiaries, or you have a beneficiary that you want an asset or you want to benefit from your trust or from a specific asset over time. And where we are avoiding the probate process, that time frame of how long a trust can continue is not governed by the probate process. So again, if we have beneficiaries or a plan that we want to extend over time or over generations, a trust is really going to be the best way to do that and won't require ongoing probate oversight and involvement. As I mentioned, fully amendable during your lifetime, you have complete control. And those assets that are in trust do not pass through the probate process so long as they are in the name of the trust or payable to the trust when you pass away. So a lot of the planning that we talk about involving trusts, we review very carefully to make sure that that trust has been funded. Those assets are truly titled in the name of the trust. Trust can be a beneficiary of life insurance policies. The trust could be a beneficiary of IRAs. But again, keeping in mind that there have been some changes to the laws governing IRAs, and in particular, how that might impact your plan or how your trust may have been drafted with respect to receiving an IRA. So certainly review those with counsel. And the trust can be the recipient or the beneficiary of a refundable entry fee, such as a CCR fee that Kim had mentioned earlier. And then again, I think I hit upon this on every session we've had, you always need to be reviewing your estate planning documents. There might be changes in the tax law, changes in state law, changes in laws that govern the probate process. Maybe it's not as horrendous a process as it used to be, and we don't mind going through that process and can simplify a plan with respect to the probate administration and the probate process. Maybe you move to another state and it's just a very simple process, or you move to a state where the probate process could be really complicated. So it's always worth reviewing during your lifetime, and any change in state laws or change in your circumstances if you move to another state. Again, reviewing that trust, if you have one, to make sure that it is funded, and also reviewing the selection of the folks that you've named to serve as administrator, executor, trustee, agents under your power of attorney, to be sure that those are still really the right people for that job. So we know probate is a process that's overseen by a probate court or equivalent. You can avoid that process by titling assets in certain ways, either jointly held or naming a beneficiary or a payable on death designation, or placing those assets in trust. But nonetheless, you should always be reviewing titles to assets that you have now or any assets that you acquire in the future, just to be sure that you understand how those will pass to your beneficiaries when you pass away. So I know we covered, again, a lot of stuff in a really short period of time, but I'm happy to take any questions now, or my contact information is here. So feel free to reach out to me separately later on. Thank you.
Thank you, Jennifer. It was a wealth of information and expertise, and we appreciate it. I really enjoyed how you circled back to review some of the prior presentations as well. So it kind of all weaves together as a reminder for me. So you can go ahead now and submit your questions in the Q&A function at the bottom of the screen, and we'll give everyone a moment to do that. And I'll just mention our next event coming up is on Tuesday, February 23rd. Birch Hill is celebrating our brand new executive director, April Bordon, started her position in November of 2020. She brings so much energy and experience to our community, and we're excited for everyone to, excuse me, get an opportunity to meet her, ask her questions, and learn about her vision for the future of Birch Hill. So with that being said, we have a fair amount of questions here. Okay, so this one is, can a trustee of a revocable trust also be the beneficiary of the same trust?
That's a really good question, one that I've received a lot of clients ask that. They can, and I say that with a slight hesitation. But yes, in general, a trustee can be a beneficiary of a trust. There might be certain conditions or limitations we want to put on that trustee, particularly if that trustee is making discretionary distributions to themselves as a beneficiary. So we might want to limit some of that discretionary language. But yes, the answer to your question is yes, they can be.
Okay. The next person asks, could you elaborate on interested parties? Does that include spouses of adult children?
So spouses of adult children. So again, so here's the lawyerly, it depends, right? So in general, the interested parties in a probate are going to be the people named in the will to receive assets. It's also going to include children, potentially grandchildren, particularly if we have a child who has passed away, but they are survived by children. So sometimes we'll go down the line of the family tree, but typically it is just your bloodline. So it is not spouses of a child, for example. So your daughter-in-law or son-in-law or grandson-in-law or granddaughter-in-law are not an interested party in the ordinary course. If, however, they are named as someone in the will to receive an asset, then they would be an interested party. So I hope that answered the question, but ask further if not.
Okay. Regarding trusts, what is the cost range for trust costs?
So cost as far as setting up a trust,
Okay,
maybe?
yeah, I think that's what.
Yeah. Okay, so I'll and then I can elaborate a little bit further, but cost of setting up a trust is typically part of your estate plan. So different attorneys or estate planning professionals address those in different ways. Some might have a flat fee type of arrangement. Some may bill by the hour. But in general, if you, I think, and it will depend in part where you're located, right? But in general, it might be a couple $1,000s. And if you have a really complex plan, you know, it might be a little bit more than that. If it's pretty straightforward and simple, it might be a little bit less. But, you know, it's not inexpensive, but it's generally cheaper than having to go through the probate process. And it gives you a sense that you know that your instructions are going to be followed. As far as ongoing trust administration, there might be costs involved in that, particularly if you have a professional trustee who is going to be managing your trust after you've passed away. So those are typically on some sort of fee schedule, and it may be dependent upon what assets are being held under management or whatever structure that trustee thinks is part of their fee schedule. So I'm hoping that answered that question. But there are costs involved, but in general, it tends to be easier and less expensive than a full-blown probate administration.
Yeah, it sounds it. And there's just one last question. Are there any specific rules about how property can be disposed of?
Oh, good question. So the property can pretty much be distributed or disposed of in any way that you want, as long as you've written it down in a will or in a trust. So there are very few limitations on distributing property. Where we run into issues sometimes is if we have an asset that just is not easily transferable, right? Or we're going to leave a piece of real estate far up north, you know, to my child who has not set foot in New Hampshire for 15 years. So there might be some challenges on that end of things, but there typically are no restrictions on who you can leave property to or how property can be transferred. It depends a lot more on the beneficiary who's going to be receiving that property and whether or not we need to have some contingent plans in place if they're not in a position to accept an asset in kind, for example, or if they're a beneficiary that is receiving some sort of medical benefit, perhaps a Medicaid or Mass Health or some sort of resource-based benefit, and we don't want them to receive that asset because it might disqualify them from benefits. That again is more of a planning, a piece of the planning discussion to be sure that whatever you're thinking about distributing gets to the right person under the right conditions. But in general, no, you can leave assets to whoever you would like.
Wonderful. And is property considered what is held inside a house? even if the house has been left to someone outside of the probate?
So that really kind of depends on what the terms of the will say, for example. So a lot of wills will say, I'm leaving, the house to Joe, including all of the contents. Sometimes we are leaving the contents and tangible items to someone else to be divided. So again, instructions are really helpful in either a will and or a trust to help us to understand what it is that you want. But typically, at least, in my experience, real estate may pass to one person under the terms of that document, estate planning document, and the contents may end up going elsewhere. But to the extent that we get some direction is always very helpful. Otherwise, they would be treated as different assets. So real estate is one thing, tangible items are another.
Great, thank you. I don't see any other questions. So with that, I guess we'll wrap things up for the day. Thank you, Attorney Rivett, for your time once again.
My pleasure. Thank you. And thanks for all the great questions. Have a great day. Stay safe.